Let's take a look at a key case within the law of tort. This is the case of Ward v Tesco Stores Limited, 1976. Let's take a look at the case facts. In this case, the claimant was Mr. Ward and the defendant was Tesco Supermarkets. The claimant was completing their shopping in a Tesco supermarket when they slipped and fell on some yogurt and suffered minor injuries. They sought a claim in negligence against the defendant upon the basis that they did not have adequate procedures in place to ensure that people were not injured from spillages. The procedures that they had in place in order to prevent injury was that the floors were swept 5 to 6 times a day, and staff were given clear instructions upon what to do if they found a spillage. They were told to stay with the spillage and call for help. They also accepted that it was part of the ordinary course of events that there were spillages in supermarkets, and that because shoppers were concentrating on getting their shopping, they could not always ensure that they did not step in places where there were spillages. The outcome of this case was that the defendant superstore Tesco's was found to be liable. They were found to be liable because they owe a duty of care to all of their customers whilst they are within their stores. It was felt that they were in breach of their duty of care because they had failed to take practical precautions during the time that the customer was in the store. The defendants were unable to demonstrate that there was a clear and efficient system in place to clean up the spillages. Because it was well known that spillages were part and parcel of daily life in a supermarket, it was felt that the system of sweeping the floor 5 to 6 times and ensuring that staff stay with spillages if they find them, it was not felt that that was adequate, given that it was widely accepted that there were often spillages. It was held in the judgment that they could have escaped liability if they could have proved that such an incident was likely to happen, even if all proper and adequate care was taken, and it was not felt that Tesco's could prove this in the case. The court said that they had not taken all reasonable care, they had not taken all of the practical precautions given the likelihood of the risk. This is therefore a key case which you can refer to in an application question when you are assessing if a defendant has taken sufficient precautions when balancing this against the likelihood and seriousness of the risk.